Jefferson County Court Law number 2 is now in session. Court is in session in two cases on a special review docket. The first case is cause number 332-464. Second case is cause number 332-466. Both cases are styled the state of Texas versus Demetrius Miles. We have Mr. Miles appearing via Zoom. Mr. Miles, is that your full name, Demetrius Miles?
Yes, sir.
Mr. Miles, would you please raise your right hand? Mr. Miles, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Mr. Miles, you may put your hand down. How are you doing, Mr. Miles?
I'm good today, Your Honor. How you doing?
I'm doing fine. Thanks for asking. Mr. Miles, you're represented in your case by your attorney, Langston Adams. Attorney Adams, how are you doing?
Doing well.
That's good. Mr. Adams, do you waive a record in Mr. Miles' case?
Yes.
Okay. State is represented in this case by attorney Lamar Johnson. Attorney Johnson, how are you doing?
I'm blessed, Your Honor. Thank you.
Okay. Now, before we get started, I have before me a document commonly referred to as an assessment, collection of information on a form for mental illness and intellectual disability. Mr. Adams, did you receive a copy of the assessment?
Yes. Yes, sir.
And Mr. Johnson, did you receive a copy of the assessment?
I did, Your Honor.
Now, Mr. Adams, do you have any objections to the finding, conclusions, and recommendations in this assessment?
No.
And Mr. Johnson, do you have any objections to the findings, conclusions, and recommendations in this assessment?
No, sir.
Now, the court is going to take judicial notice of this assessment, which is titled Collection of Information Form for Mental Illness and Intellectual Disability. The court finds in this report, let's do this here. And what I'm going to do, just temporarily pursuant to Article 1.24 Texas Code of Criminal Procedure, all proceedings and trials ought to be public. However, pursuant to Lilly versus State, the right to an absolute trial, the right to a trial is not absolute, and it may be outweighed by competing interests, such as interest in security, prevention or preventing disclosure of non-public information, or ensuring that the defendant receives a public trial. Mr. Adams, the information that the court is getting ready to go over is non-public. Are you requesting that this portion of the hearing be closed to the public?
Yes.
Prevent the non, okay. So this portion of the hearing is going to be closed to prevent the non-disclosure of public information. The court finds that the party seeking to close the hearing have advanced an overriding interest. The closure is no broader than necessary to protect the interests of the defendant, that is to prevent the disclosure of non-public information. The trial court has considered other alternatives or other reasonable alternatives, and these findings that the court makes are adequate to support the closure. So at this time, this hearing will be closed.